Hello everybody, welcome to iExamB's Legal Beat. This is Amrita, your law faculty at iExamB. In this video today we are going to discuss another question from the Judiciary Mains answer writing series that has been started exclusively at Legal Beat. Let me tell you the benefits of this series. आप अगर ये वीडियोस देखते हैं तो आपको जुडिशरी के अलग अलग कंसेप्ट्स पर क्लैरिटी मिलती है, आपके कंसेप्ट्स रिवाइज होते हैं एंड आपके आंसर राइटिंग स्किल्स भी डेवलप होते हैं. यू आर एबल टू अंडरस्टैंड द पैटर्न इन विच यू हैव टू राइट आंसर्स. इसके साथ ही आप इन पीपीटीज को डाउनलोड करके अपने पास रख सकते हैं एंड इन पीपीटीज से आपके पास एक रेडी रेफरेंस तैयार हो जाता है फॉर डिफरेंट कंसेप्ट्स एंड डिफरेंट आंसर्स ऑन डिफरेंट टाइप ऑफ क्वेश्चंस एज वेल. सो दिस इज समथिंग विच इज़ वेरी एक्सक्लूसिव एट लीगल बी. सो ट्राई टू टेक बेनिफिट ऑफ ऑल दीज थिंग्स. अगर आपको किसी क्वेश्चन पर आंसर की ज़रूरत है, यू कैन राइट टू अस इन द कमेंट सेक्शन ऑफ दिस वीडियो और यू कैन राइट टू अस एट hello@iexamb.com. Call on this number and get all the details for exam course preparations and visit the website www.iexamb.com for more details. So in this video we are going to discuss question number 6 actually. This is the 6th question from the series. Explain the concept of precept under the Code of Civil Procedure and also the circumstances under which an order for attachment before judgment is passed by a civil court. So ये बहुत ही important concepts है CPC में से. One is precept and one is circumstances in which attachment before judgment can be passed by a civil court. So first you have to start with what is a precept. Precepts means a command or an order. A precept means an order or a direction that is given by the court which is passed that a decree to a court which would be competent to execute the decree to attach any property belonging to the judgment debtor. Section 46 of CPC incorporates this concept which talks about precept, that the court which has passed the decree may upon an application made by the decree holder. So in this case always remember that for precept the decree holder has to make an application. Decree holder has to make an application to the court which has passed the decree, issuing a precept to that court within whose jurisdiction the property of the judgment debtor is lying to attach that property that is specified in the precept. So first you have to give a brief introduction of the concept of precept and section as well, and then you can give an idea that how it is going to be working out, how the procedure starts. पहले application file किया जाएगा जो decree holder करेगा. Which court will be taking up that application? The court which has passed the decree. And then actually why the concept of precept is so important, I will tell you. Like that you can come towards the main points of the answer. That is, the judgment debtor's property is lying in the jurisdiction of a different court. That is why the court passing decree is actually issuing this precept. So the jurisdiction where that property is lying is actually the court which is entitled to take action against the judgment debtor's property. So the court to which a precept is sent shall proceed to attach the property in the manner prescribed in regard to the attachment of property in execution of a decree. There is a proviso clause which is very important over here. You have to pay focus on that also. Since they have asked the question which is very general in nature, so you have to cover the points relating to everything, even the proviso clause. Moreover, the proviso clause is giving up a time period, so it is very important you have to cover that. Provided that no attachment under a precept shall continue for more than 2 months unless the period of attachment is extended by an order of the court which has passed the decree, or unless before the determination of such attachment the decree has been transferred to the court by which the attachment has been made and the decree holder has applied for an order of sale for such property. Accepting all these circumstances, attachment under a precept shall not continue for more than 2 months. Clearly यहाँ पर दिया गया है कि ये precept का जो order है ये एक temporary nature का order है और ये सिर्फ 2 months तक valid रहेगा. So this is very important point. That's why I have underlined it over here. Section 46 of CPC entitles the court passing a decree issuing a precept to any other court competent to execute a decree to attach any property that is belonging to the JD, and the latter court is bound to obey. ये भी एक important point है that the other court should obey it. The court is bound to obey the precept actually. Principal object क्या है? अब ऑब्जेक्ट पे आना बहुत ज़रूरी है. एक बार आपने कंसेप्ट समझा दिया आपने एक बार कंसेप्ट के peculiarities बता दिए, सेक्शन बता दिया, that is the relevant provision, then you have to come to the object behind that provision. This is very important flow. इस flow में ही आपका आंसर जाना चाहिए. So what is the object behind this? The object of this provision is to prevent the judgment debtor from disposing of his property before the decree holder can get the decree transferred and take steps in proper court for execution against the property. So in execution, you have to remember that the ultimate objective is to make the decree be satisfied. Make sure that the decree holder is able to enjoy the fruits of that decree is the very objective of execution proceedings as well. And that's why precept से हम उस property को hold करके रखते हैं. This is what is the crux of this provision. So it becomes necessary that a precept is issued under section 46 of CPC when the judgment's debtor's property is situated in that court's jurisdiction only, that has to be issued. And yes, again the 2 months point is very relevant over here. And one more thing arises over here, that the question arises whether precept is a transfer of decree to another court. Just because there is jurisdiction of judgment debtor's property in another court, so are we transferring the decree to another court? So the question will be answered in negative. Why? Because ये transfer of decree नहीं है. Transfer of decree का process altogether different है. ये प्रिसेप्ट का ऑर्डर है जो सिर्फ स्पेसिफिक प्रॉपर्टी के लिए एप्लीकेबल है, जो स्टेटस को मेंटेन करेगा, एंड दैट विल बी ओनली फॉर 2 months. वी कैन नॉट फॉरगेट दिस प्रोविजन. सो दिस ऑटोमेटिकली मेक्स इट क्लियर दैट द प्रिसेप्ट डज नॉट अमाउंट टू ट्रांसफर ऑफ अ डिक्री. ऑल दीज थिंग्स विच आर ऑटोमेटिकली arising impliedly, they are covered under the concept, those also you need to take up. यानी कि जैसे अभी हमने ये क्वेश्चन डिस्कस किया, जो अराइज होना बट ऑब्वियस है कि प्रिसेप्ट ट्रांसफर ऑफ डिक्री है क्या. सो हमें हमारे आंसर को इलैबोरेट करने के लिए इस तरीके के पॉइंट्स ऐड करने बहुत ज़रूरी है. दिस शोज दैट वी आर हैविंग अ साउंड नॉलेज ओवर द सब्जेक्ट. Any order of precept is merely a step that is taken to facilitate execution and not an order for transferring a degree of execution. So you have to remember that. Then coming to one case law on the point, that is Syed Abdul Rahman versus Tripura Modern Bank Limited, 1972 का case है ये. In this case, what had happened? The decree holder has to make an application to the court passing the decree for transfer of decree. If the property which is sought to be attached and sold lies beyond the jurisdiction of that court. Sections 33, 39 and 40 of CPC deal with transfer of decree from one court to another court. जैसे कि मैंने आपको ये प्रोविजन के बारे में अभी बताया, ये प्रोसेस के बारे में बताया कि ट्रांसफर ऑफ डिक्री एक ऑल टुगेदर डिफरेंट प्रोसेस हो जाता है, तो ये केस लॉ यहाँ पर रेलिवेंट है. दैट्स व्हाई इट इज इंपॉर्टेंट टू साइट इट ओवर हियर. ट्राई टू इंक्लूड केसेस इन योर आंसर्स एज वेल. Now coming to the next part of our answer of our question, actually, that is attachment before judgment. What is this attachment before judgment? First of all, you should be very clear with all the important topics and the relevant provisions. यहाँ पर आपको रूल भी याद होना ज़रूरी है. जुडिशरी के आंसर्स के लिए डेप्थ नॉलेज बहुत ज़रूरी है मेंस आंसर राइटिंग में. At least the important topics you need to remember. So the powers of civil court to direct the attachment of any property before judgments are derived from and are regulated by Order 38, Rule 5 of the CPC. This rule empowers what? It empowers that the court can attach property belonging to the defendant which he is about to dispose of or about to remove from the local limits of the jurisdiction of the court. So what is the object of this provision, Order 38, Rule 5 of CPC? It is to prevent any attempt on part of the defendant to defeat the realization of the decree that may be passed against the defendant. यहाँ पर इन्होंने precept और ये provision साथ में क्यों पूछा है? Because दोनों का objective near about same है. यहाँ पर भी आप जो कर रहे हो, आपका object क्या है? That the defendant has to, the defendant should not make any attempt to defeat the realization of the decree that has to be made on behalf of the plaintiff. That is in favor of the plaintiff. What is another object? Another object is that the order leaving attachment before judgment is to give an assurance to the plaintiff that his decree, if made, it would be satisfied as well. So the object of invoking Order 38 Rule 5 is what? It is to safeguard the interests of the plaintiff If the court is satisfied that ultimately when a decree is going to be obtained by the plaintiff, he may not be able to realize the fruits of the decree. So what is the purpose of attaching it? To prevent defendant from taking such coercive actions, and the plaintiff should be able to utilize the fruits of the decree. What is the main objective is that? So safeguard the interests of the plaintiff. इसके लिए सप्लीमेंट्री प्रोसीडिंग्स बनाए गए हैं सीपीसी में. इसके अलावा और सप्लीमेंट्री प्रोसीडिंग्स हैं लाइक एप्लीकेशन फॉर अरेस्ट और अटैचमेंट बिफोर जजमेंट, grant of temporary injunctions and appointment of receivers is to prevent the ends of justice being defeated. The object of Order 38 Rule 5 CPC is to prevent any defendant from defeating the realization of the decree that may ultimately be passed in favor of the plaintiff. Either that can be done by attempting to dispose of or remove from jurisdiction of the court his movables as well. So that is why Order 38 Rule 5 of CPC is a very important provision. And if the court is satisfied by an affidavit or otherwise that the defendant, with the intention to obstruct or delay the execution of any decree that can be passed against him, is about to dispose of, if suppose there is such kind of thing is made clear that he is going to dispose of the whole or part of property, if the court is satisfied, and of course an affidavit has to be taken for that. That is a procedural requirement, that the defendant is about to remove whole or part of the property from the local limits of the jurisdiction of the court itself. अगर ऐसा कुछ भी होने वाला है, ऐसा कुछ भी होने का apprehension अगर है, तो attachment before judgment का provision यहाँ पर बहुत helpful होगा और यहाँ पे apply किया जा सकता है. This you can understand the objective of execution needs to be saved over here. There is one more important case law which you can add over here. Raman Tech and Process Engineering Company versus Solanki Traders 2008. In this case particularly, court has made observations relating to Order 38 Rule 5, and also the court has mentioned that this power has to be exercised sparingly. It is an extraordinary power of the court, and that has to be exercised sparingly means what? Not in each and every case. Only when the court is satisfied. The discretion of the court is very important over here. It should not be misused. Power should not be exercised mechanically or merely for the asking. Defendant is not debarred from dealing with his property merely because a suit is filed or about to be filed against him. Shifting of business from one premises to another premises or removal of machinery to other premises is by itself not a ground for granting attachment for judgment. Really ऐसा कोई threat prove होना चाहिए. अगर सपोज डिफेंडेंट प्रॉपर्टी के साथ कुछ डील कर लेता है, दैट डज नॉट मीन इमीडिएटली आपको अटैचमेंट का ऑर्डर मिल जाएगा कोर्ट से. आर यू अंडरस्टैंडिंग द ऑब्जेक्टिव ऑफ दिस प्रोविजन? सो दिस केस लॉ इज वेरी वेरी इंपॉर्टेंट. इस केस में काफ़ी अच्छे से एक्सप्लेन किया गया है. इस केस को आप अच्छे से समझ सकते हैं एंड अपने क्वेश्चन में एज एन आंसर इसको ज़रूर इंक्लूड कीजिएगा. आई हैव शेयर दिस एंटायर स्टेटमेंट ओवर हियर. इतना ध्यान में नहीं रहता है. आई कैन अंडरस्टैंड व्हेन यू आर फ्रेमिंग योर ओन आंसर्स, बट ट्राई टू write the crux of the case as much as you can remember, at least the important points. So this was all that I had to discuss with you all from this topic. It is a very important topic from CPC, Precept and Attachment Before Judgment. Do go through this. If you have any doubts, you can reach out to us at iExamB. And also there is a free expert session with at iExamB with Robin Dutt sir. He is a senior counsel having a experience of more than 25 years. The High Court and Supreme Court of India. There is a guidance session relating to litigation, judiciary, ADA and other courses. So do subscribe to our YouTube channel and register for the workshop as soon as possible. Thank you everybody.